one of my favorite presenters, Danielle Butler. Danielle Butler, where are you? We have the customary walk for Danielle up. She will do a saunter as she approaches. She's one of our best legal minds in the industry. She spoke last year, I believe, as well. Her presentation is marked legal. She will be giving us all information specific to the legal community in everything. Does that
Great.
cover
Okay,
it?
good. Yes.
Yeah.
Yeah. Okay. Thank you. Thank you very much. Would anybody have a extra water, or can I get a water? I have a little. Oh, I guess I don't need that. That's right. These kind gentlemen put this microphone on me. Thank you, everyone, for that very nice welcome, and thank you very much for calling on me to come and speak to you about what's going on in your industry concerning the effects of the hurricanes. So just some ground rules. There'll be no booing, no frowning, no arguing. I have my bouncer right there. He is paid to protect me. And at the end of the day, remember that my interpretation as a lawyer could be different than your in-house counsel attorney. It could be different than the arbitrators that you appear before. It could be different than the judge or the jury you go before, because our job as attorneys is to review the law, interpret the law, and apply the facts of the scenario to the law in our client's favor, of course. But I know I've been in this hot seat before, and I know you're all looking for yes and no answers. And I'm sure if you've been doing this job for more than a year, you know that in your industry, there are very few yes or no answers. There's a lot of gray, and it's extremely fact-intensive, and each dispute holds its own, meaning that if you come to me and you say, I have an issue and here it is, it's probably going to be completely different than the next person's issue. So I can't just give you a blanket answer. There's going to be, you're never going to find a flow chart or an Excel spreadsheet with your answers on it because of our assets, what we deal with, the nationalities of all of the different people, the nationalities of the vessels and jurisdictions, and on and on and on. So I've got here your Bibles for your industry, your IYBA agreement, which was sent to me by both Jeff and Daphne, and then, of course, the AYCA, both the uninspected and the bareboat agreements. So just what I wanted to do, there's no slideshow, no presentation in that manner, because I think what I found was I got out of my instructions from both Jeff and Daphne were to first just point out the obvious, or maybe not the obvious, that might answer some of your general questions out of these agreements, which I think we could go through quite quickly, because I'm sure that most of you know this by heart, and probably at this point better than me, especially after the last month. And then the second thing is just open it up for general questions, and that's when I'm going to ask my bouncer to come and sit next to me, because I'm not going to be, some of them is going to not give you the answer I think you want. But so let's start with just the IYBA agreement. And I want to point out some things upon my review that I think are interesting. So the general factual scenario, of course, is what is going on with the destruction from, obviously, Harvey, Irma, and Maria. And hopefully not any other hurricanes, but we don't know because we still have another month to go. And how is that affecting your charters, and whether you're representing the charterer or the owner or your own personal stake in the business deal? So as a business owner, I also want to talk to you like a business professional, because sometimes I could tell you what the legal answer is, but that might not benefit the overall business answer. So, the two are part and parcel. I definitely do believe that, and I think now as being business owners, we realize that some, the law there might be a black and white answer, but that might not fit the actual transaction. and what your parties want. So just going quickly down the IYBA agreement. So the IYBA agreement that I received, there's one important change that I received on this. And if this just might be an example of a change that was sent to me but might not be standard in the IYBA agreement, but I needed to point it out because, as you know, first and foremost, 101 contracts, this agreement is between the owner and the charterer. So essentially, you all are stakeholders, meaning that from their agreement, you're getting a benefit, which would be your commission. But this agreement is between the meetings of the minds between your owner and your charterer. So what does that mean? Well, you all have a section here called special conditions, meaning, although we know we don't like to see changes to these form agreements, your party or your parties to this contract have the ability to change anything in this contract and memorialize it in your special conditions, okay? So, like, I'm going to point out this most important one. All parties agree that should arbitration take place, it will be held in Broward County, Florida, by the Miami Maritime Arbitration Council. So what does that do to the effect of this contract? Well, if you turn back to clause, the law clause, in the contract, it actually says that the law is under British law, the venue is in London, and the governing body is the London Arbitration Association. So what this one provision now did is change 2 out of those 3 things, which I'm going to also give you a free tidbit here, is that all it's changed is your venue. So now you no longer have to go over to London. And 2, your governing body, which is now you no longer have to go before the London arbitrators. But this contract is still governed by English law. And let me tell you what a complete, I'm going to be very frank here, pain in the ass that is. And I could tell you why, because I'm currently dealing with a dispute, and this is a sales dispute on a yacht sale, where we are in Dallas, Texas, before the Dallas Arbitration Association under British maritime law. And we might as well have just flown over to London. It would have been faster, easier, and cheaper than having to find Dallas arbitrators that have any clue what we're talking about in the maritime industry, and then on top of that, under English law. So, yeah. It was what the parties agreed on. Now, I got the contract like that, so my thing was, and who doesn't have a strong-willed, super type A OCD owner, right? Okay, so when I received the contract, I said to them, why did you do this? Well, because I live in Dallas. I'm not going to London. Okay, great. Okay, so why'd you do Dallas arbitration? Well, because, again, I want it here in the U.S. I said, that's great, but you realize this is an American law. This is not Texas law. He's a Texan, so everything's got to happen in Texas, right? So, and he's like, what do you mean? What do you mean? I'm like, well, you only changed 2 out of the 3 parameters that affect what's going to happen with your dispute. Wasn't really happy, but you're governed by the 4 walls of this, the 4 corners of this piece of paper, period, end of story. So that's the first thing that I want to bring note to, and again, remember 3 things that you have to change. Otherwise, it's going to be a logistical nightmare. So then going through this, very basic, but again, these are now solid legal binding clauses in your contract, and that's about the delivery and talking about, well, we just had these hurricanes. Does my owner need to deliver the vessel, or can they change the location? Not without, so if your contract, if your first page of your contract says St. Martin on December 1st, without a meeting of the minds, meaning both parties agreeing on a change, then that boat better be there on St. Martin on December 1st, barring these things: force majeure, the fact that the insurer of that vessel says, you go to St. Martin, you're not insured. Now, currently, I have reached out before this seminar to 3 of what I think we would all consider the most prominent charter insurance brokers in our industry. And none of them have told me right now that the insurers have excluded any of the hurricane zones. Now, typically, yes, Cuba and Haiti, but that has nothing to do about the hurricane. So St. Martin, Dominica, BVIs, USVIs, Puerto Rico, none of them are excluded under coverage, so your insurance is still applicable. Now, the other governing bodies that you have to be concerned about, your flag state of the vessel, if it's Marshall Islands, if it's BVI, if it's Cayman Islands, if there is a notice that you've received saying that that flag state will not permit any vessel registered with their jurisdiction to go to any of these areas, then that vessel cannot go there unless you change the registration of the vessel. So far, none of those notices have been issued. The last way is if the actual port state or nation says, we are not accepting public transport, we are not accepting vessels to come into our marina. As far as I know, and I'll be honest on this, I don't have the latest information on that, but as far as I know, I haven't heard of any exclusions, and these islands are desperate, and they make their income by tourism. So those are definitely your ground rules on that. Now, let's turn to the business aspect of that. The best way to resolve any of these disputes, you know, is trying to work it out between the charterer and the owner. Because any maritime attorney in this room will tell you, and even if it's a very large yacht and you're getting $150,000, $250,000 for the owner for the actual charter hire, going over to London and taking you all with us and arbitrating is very expensive. So sometimes the worst settlement is better than the best lawsuit. Now, I understand, let's go back to our super type A OCD clients that get up on their soapbox and start pounding. It's all about the principle. And again, I think any maritime attorney could tell you after a year, because even if it's arbitration, it's still going to take at least a year, because that's what attorneys do, you know, that we get into we get our litigator hat on, and the next thing you know, something that probably could have took 3 months is now taking 3 years. So it's going to take about a year, maybe if everybody agrees, less than that. But within a year, I could guarantee you that the principal has quelled down considerably. And now they're pissed at you, they're pissed at us, because they just got our legal fee bill for $100,000, you know, or whatever it may be. So that's the reality of the situation. That's not the law, but that's the reality of the situation. And when somebody calls us up for litigation, not that we're in the business of turning down business, but we always tell our clients that come to us about litigation, all of that. Then we put it in writing, so a year later, and they're all pissed off at us because nothing's resolved and they've now paid all this money, we're like, well, do you remember when we told you about what this is going to look like? And then 6 months later, you maybe should settle. So I guess the next, which I'm sure everybody in here knows, but I always like to repeat it because you can't hear it enough, always, always document your conversations with your clients in writing, send it to them, make sure that they get it. So that's your little CYA, right? We all know about that term. So the next thing in this agreement that I looked at that I thought was interesting was, of course, you know, your clause 9. This is IYBA again. Now, your your delay in delivery, failure to delivery. I know you all know that cold, but what I thought was interesting was. Firstly, I have to congratulate every person in this room that worked on negotiating these contracts, because probably the burning question in your mind is that under force majeure, do you still get paid your commissions? The answer is yes. It is crystal clear in here. So that is absolutely fantastic. So no matter what the reason is, you get paid your commission if this contract is signed by both parties and there's a deposit in hand. However, now let's turn the tables. Is it prudent to accept your commission as a business person if you ever want to do business with that owner or with that charterer again? And I can't answer that for you. That's only something that I bring up because I know Andrew and I have had that conversation before. You know, is it worth going after that client for these legal fees and, I don't know, having your reputation tarnished because, you know, they know more and blah, blah, blah. But so that's just always something to consider than just, well, you know, under clause, where is it? Because it's so clear. I thought that was brilliant. Under clause 18, you know, it says notwithstanding, you still get paid your commission. So you could you could tell them that, and maybe some will say, okay, I understand. I read the contract, which I guarantee you they probably didn't. I understand I owe you a commission. I'm going to pay you a commission. But, you know, so there's more than just the black and white sometimes. So let's talk about force majeure. Actually, wait, before that, let's talk about clause 16, which is insurance. In there about your insurances, I just wanted to point that out because it is the obligation of the owner to have insurance. So that circles back to what I said to you about if you have a question about what we're discussing, which is can they go there? Don't ever forget to call if you are the charter manager, to call the owner's insurance broker and check that out. That is huge to make sure that you could legally, or that the insurance policy is still binding in the jurisdiction in which you're going to. So then let's talk about the most important, which is your force majeure clause. And just about every contract that we draft, whether it's in the maritime industry, jet, whether it's in someone purchasing a home, where, you know, construction contract, you see force majeure. So obviously you know that force majeure is not, it's not our maritime term. It is a legal term personified. So force majeure is just, it's a clause that's just, it's kind of like your, you know, I'm not going to say the bad word, but poop happens, right? You know, take it from there. That's that clause. That's what that means. Sometimes stuff happens that is beyond everybody's control, and it's just not fair. It's just not equitable to hold people to the contract anymore. That is the essence of force majeure. Now, because our industry is fantastic, we like to take force majeure and really just stretch it to its limits. So in here, typical force majeure is, of course, riots, acts of terror, blockades, invasion, war, storms, hurricanes. What's not typical, of course, but applicable to our industry is contaminated fuel, because that truly is beyond your control. If you go to a reputable fuel carrier and it's just, maybe that fuel carrier didn't even know that they received infected or contaminated fuel. Major mechanical breakdowns, because it's a yacht. I mean, I have a boat and I can't, yes, it's definitely that hole that you throw money into. They'll love it, but mechanical and electrical breakdowns happen all the time. Now, of course, if it's just because I'm lazy and I don't want to throw that money at taking care of the boat, then no. If you're just negligent or just a bad owner, you can't use that excuse. But listen to this again. So crew changes and shipyard deliveries are not applicable to force majeure. But I want to go to something that was said before. So your force majeure clause, and I'm going to just throw this out here, and I think this might be, it will be a bit controversial. So this clause is in here. It does not say anywhere in this agreement that it's applicable to one party or the other. But what happens if your charterer lived in Las Vegas and was part of what happened, unfortunately, a couple of days ago, okay, and called you up and said, my wife was injured or my wife was shot or whomever, right? Something happened during that which I think anybody can term a riot, would you think that the charter is then legally applicable to call and cancel this charter? 24 hours beforehand, 48 hours beforehand. And I want to put that seed in your mind, just as in, yes, this clause is definitely written for the owner to get out of things that are beyond their control, because that boat, they have to get that boat to that delivery location in order to start that charter. But sometimes, now, charter not being able to buy commercial plane tickets to get to the vessel to start their charter, that is not force majeure. I mean, you could buy a plane, right? We all know you could buy a plane, or now we know you could charter a seaplane or whatever. So don't give me that excuse. But if the excuse is something that's applicable to the charterer underneath these very specific provisions, really, is it what fire? What happens if 24 hours or 48 hours before their home burns down? That's fire. So just, I want to point that out. Hopefully that's never happened to anyone, but just understand that if your charterer does call you and has something that smells like a duck, looks like a duck, and walks like a duck, then definitely go to the charter broker, have a conversation about it before you just say that force majeure doesn't apply. And then I think there was one more clause. Okay, no, we already talked about the arbitration clause. Now, pretty much your AYCA, there's nothing significantly different that I could address that are like little nuggets that I don't know if they're obvious to you, that are different than what I saw in MIBA. So what I'd like to do now is just open it up to any general questions, and I'm happy to answer them.
We have like a 10-minute warning here. Hold on.
This sort of goes back to one of the scenarios before, but pertains a little bit to what you've been touching on with brokers. Does it make a difference if a broker puts their name along with the company or brokerage in a situation where they potentially move on to another brokerage firm, and that whole three-way split that we were kind of discussing in the scenario, versus what was sort of more of a standard before, where it's really just the brokerage name as the broker versus a person's name as the broker?
Well, again, so we now in the state of Florida, we now have, although few, but we do have case law concerning commission disputes in our industry. Maybe they don't cover every exact scenario. So if we were to go, now this is arbitration, we go to arbitrate when it comes to here. But the arbitrators still look at the state laws, and we're just going to go with Florida for that because we're here. So the first thing that they have to look at is, within this industry, is there case law in point? If there isn't, then they go to the next mirror image of our industry, which here would be real estate. And so we've had litigation concerning broker commission disputes, and we've had to use real estate law because obviously there's an abundance amount of litigation and law concerning real estate brokers. So the fact of the matter is that now it's very transparent that the brokerage house has an actual person that's dealing with it. The brokerage house is not a beating heart at the end of the day. Yes, there's a shareholder there. The parties. So, now, when litigators recommend, there's going to be some transparency because that's the first thing in the state of Florida that we're going to look at. I mean, if it's in black and white, it is the best way to show, well, really, they're not involved, or, Joe Smith really didn't have anything to do with this. It says it right here on this charter contract. Otherwise, then, we've got to elicit that factual scenario through discovery of depositions. And unfortunately, we know that people lie, right? So the other way of looking, so if it's not here, excuse me, I just hit the microphone. If it's not here, maybe it's in one of your emails, because you could print that out. Now that's black and white, right? The next best way, although still not effective, is phone calls. You could print your phone bill and say, there is evidence that I spoke to this person on this day at that time, and here's the actual phone call, the phone number, and the amount of time. It's still not transposing what it is that you said, but in law now, we're going to look at, if you just tell me it's ABC Brokerage House, the next question I'm going to ask is, then who at ABC Brokerage House dealt with this matter? I want to know all the parties. I want all the parties involved. So I think that the fact of the matter is, there's no yes or no answer to that question, but based on what's happening when it comes to litigation, we are combing through the weeds to find out all of the particular players and what the roles are. And then that goes back to, okay, so here's the brokerage house, here's the charter broker, here's the charter manager, and then the brokerage firm that they work for. Now I want to know who did what. What did they do? Was it significant? Was it insignificant? And again, that all goes back to the evidence, the discovery, what you did. Put it in writing. Log your calls. Do whatever you can to show that, but for you, that charter would not know about that vessel. So then when you leave ABC and you go to XYZ, you still have evidence that, but for me, when I was at ABC, this transaction wouldn't happen. There'd be no meetings of the mind. Now, what your actual split is, I'm assuming, and of course that's the death of an attorney, but you should have, and I recommend this to both charter brokers, all brokers, I don't care what it is that you're selling, to have your agreement with your and again, most of you are independent contractors, but have your agreement of whatever your splits are in writing. And when you leave one brokerage house and you go to the other, before you leave, hand in a list of whomever it is your clients are, whether they're individuals or whether they're vessels owned by individuals or companies. So that's the best way in order to enforce what it is that you do, versus me being able to say an absolute yes or an absolute no, because I could guarantee you on that question, it's going to be fact intensive. Long answer. Yes, I would. If it were me, if I were doing that, yes, I would. Your name, exactly, because you have a stake in that. Now, so the brokerage company, unless it's owned by you, so that's going to be the shareholders of that company. That's their interest. But you have a separate interest. You're not employed. Well, I am assuming that most of you are not employed, and you're hired as independent contractors. So you want to make sure that you have a legal stake. You do have a legal stake because you did work, and that's what is due to you. So to eliminate any confusion, I would make sure my name is on there. Now, I know that your front page isn't set up to be like that, but I just write small and make sure everything could fit. Or type small, I guess. No one writes anymore. Yes? Yes. Mm-hmm. It is, so if you look, so our Bible, you go to a dictionary, is the Black Laws Dictionary, and you look up force majeure, and there's a canned description or definition of it, and probably it's just taken from one contract to another But if you don't like any term in here, like your client did, you scratch it out and define it. It should be a named tropical storm. It has to be a named hurricane. But who's to say, though, what about earthquakes and tornadoes? And now you're like, well, wait a minute, that's not going to affect the boat, but that's going to affect the charterer. So weather is also a very vague clause, but we see that in force majeure. What is weather? I mean, here, weather is just about everything. You hear it on the 5 o'clock news, right? So when we draft, we like things to be as specific as possible, but then, of course, you can't go crazy and have a force majeure clause that's, you know, as thick as this, right? I have seen it where an area infected with Zika virus. So, you know, again, a force majeure clause is whatever me as a charter and you as the owner agree to it as, but the standard canned language is pretty much what you see there.
Danielle, going back to page 1 of the contract where the broker is listed, if I put XYZ Charter Company / my name and Landry Yachting Inc., which I am, okay, am I not opening myself up to liability by doing so?
And I have to tell you, whether you put your name on there or not, you're going to get sued. So, yes, you are. So here's a black and white answer. Yes, you are. Because now I don't have to go on Sunbiz and search the name of your company, right? Or ask someone else what the name of your company is. But just because it's not on here doesn't mean that we're not going to find out and you're not going to be added to the lawsuit. So the answer, the strategic answer, if I were your lawyer, would be, yes, you are opening up your liability because now you're just giving notice to the world that you have a stake in this, and if it goes bad, then we're going to sue everyone. But to tell you don't do it for that purposes probably would be short-sighted because I'm still going to find out whether you're on there or not. So I don't know. What's more important is to shield yourself from a lawsuit or to make sure that you collect your interest that's due to you because
Save myself from a lawsuit. But now when I sign on page 1 as a broker below, I sign my name, my individual personal name, on behalf of XYZ company. That's how I'm currently doing it. So, but you're saying I'm still going to be sued. Yeah. Okay.
Yes. Well, and you could do that even though you're not a stakeholder or probably even a director of the brokerage house that you're associated with, because there's definitely a clear agent principal theory going on. You're holding yourself out as a representative of that company. So you could legally sign it, because I've had people ask me that. Well, you know, I don't have any ownership stake in ABC brokerage. So I'm sure we blew through the time, huh? Okay, well, I've got to go. See you later. No, I'll be here and encourage open house. So please feel free to ask more questions if you have them.
Thanks, Dan.